So awesome. I'm glad to see that many of you have decided to be on this call because all of us have some type of digital online presence. And it's really important for all of us to understand what all of those components are. Before we get started on this very dynamic talk, I do want to just bring you up to date on a few areas and some things that we're going to be doing. I can't believe it. It's October. And next month will be our last Smart Women Savvy Money webinar for 2018. We've got a tremendous schedule, very robust schedule that we have worked out for 2019, and that will be posted pretty soon. So please be sure to come back to our site to get more information about it. So first of all, as far as any of our other activities are concerned, you can always come to the event screen, and here you will be able to see some of the upcoming events and activities. We're actually, of course, this is today's talk, but this weekend we are going to be in San Francisco hosting an event for the Women's Foundation of California. Very excited about this. Team member Diane Manuel is on the board and will now soon become the president of the Women's Foundation of California. So this is going to be an amazing event. We have a tremendous, robust team of speakers and all kinds of activities that will take place, but it's also acting as a fundraiser for the Women's Foundation. So if any of you are in the Bay Area or planning to come to the Bay Area this weekend, hopefully the weather will be good, but please click here to register. We've got some great sponsors that are supporting our activities there. Also, for the next our last event will actually be in November. Dr. Frankel, who has been a major supporter of us, great author, and she also started the Bloom Again Foundation, which is really designed to assist women who are going through medical emergencies and need assistance with just their day-to-day life, getting transportation to their hospital, their doctor's visits, paying for their rent. And as you can see, she's been doing this for 10 years. So also a major event. Please, if you have any interest in what Dr. Frankel does, and I think all of us do, then this is going to be an absolutely fabulous event. This is her 10th anniversary. Another way that we like to support our smart women is to support each other in our passions, in our businesses, and anything else that we like to do. So please look for it and come into our website to find out about that. And as you can see, I'll be on Closing Bell Report a few times between now and the end of the year, which is great. Been blessed to be in that situation and continue to provide some insight. And of course, with the markets being crazy the last few days, this will be very timely. We also want to make sure, if you're not aware, to join our Smart Women Savvy Money Club, which is, this is one of the programs and platforms that we offer, but we also have a Facebook community. You will also be able to come to some of our events at discounts. And we also provide you with a tremendous amount of education about whatever, lifestyle, financial issues, family planning, all kinds of things. And so it's a great way to connect and support other women, again, in our network. And you also have access to our vetted network of other professionals. So whether it's a estate planning attorney, you need a dog walker, we have all of that information for you. So with that said, I want to jump into our program because this is going to be a very, very amazing topic. And I think we definitely want to make sure that everyone has time to ask questions and leave that time available for our two amazing speakers. Now, these are two wonderful women that actually are, we heard actually at the Financial Planning Association meeting for the Los Angeles chapter about a year ago. And their talk was so amazing that I really wanted to make sure that we were able to share their information with the rest of us because it is such a significant and important topic. We all know that we need to have some estate planning. But what happens to all of the elements of your online presence? Many of us are on social media. We have, online access to our bank accounts, to all types of different online access. What happens to those things when you pass away or if you're incapacitated in some form or fashion? So we want to do a deeper dive into that. These are our two amazing speakers, Megan Nagle. I said it right, Megan? And Laura are both attorneys with the same firm, and they're estate planning attorneys. So they're going to be giving us some insight today about how to address these issues around managing your online presence. So with that, I am going to turn it over to them. Are you guys there? We'll get you there in a minute. Okay, I see that you're changing those screens.
Here we go.
You guys there?
Do you hear us now?
Okay. Yay!
Okay.
Technology, I tell you.
Yes. That darn mute button on the computer there.
That'll
that's
do
scary
it.
that we're about to tell you about digital assets.
Okay, all right. So we want you guys to go ahead and take over, and let's get started. Anybody has any questions, and I'm sure you will, please use the chat box, and we're going to take those last 5 to 10 minutes of their presentation to answer any questions that you might have. All right? So with that, you guys take it away.
All right, thank you, Renee, for the kind words. I hope we don't disappoint. That's a lot to live up to. But my name is Megan Nagle, and I'm here with my colleague Laura Chulgin, and we are both estate planning attorneys in Century City. We work at Greenberg Glusker, and because we're attorneys, no presentation would be complete if we didn't give you the lawyerly disclosure and disclaimer. So we are not your attorneys by virtue of this webinar, and we just have to say there's no attorney-client relationship formed as a result of this webinar. And now that we got that out of the way, because we are estate planning attorneys, we feel an obligation to pitch why it is important to have an estate plan, and Renee touched upon it. But in a nutshell, the purpose of having an estate plan in place is to make sure that your financial and health decisions can be handled by a trusted person in the event that you're either incapacitated or upon your death. And we can talk for hours and hours and hours on that subject, but we'll spare you the details today. Today we're going to focus on one of the smaller components of estate planning that's become quite a hot topic these days, and that's digital assets. So what is a digital asset? It's a very broad category. Digital assets can consist of your personal passwords, your email messages, domain names, Facebook status updates, blog posts, tweets, photos, iTunes music library, your YouTube videos, your Dropbox files, your online access to your E-Trade account, your cloud storage, and any other digital data that you can think of. Now, some digital assets may only have some sort of significant personal value, but there's also digital assets that might have a financial value to you and your family as well. So for example, you might own a highly sought after domain name that could be worth thousands of dollars because someone's just dying to get their hands on it. Or you might have an iTunes account that has a balance of $100 and you want to make sure that your family's able to get that money out of the account at some point after you die. Or you may own Bitcoin if you're savvy enough. Laura and I unfortunately are not, but Bitcoin may have significant value as well. So now those are things that are digital assets, but what is not a digital asset? So digital assets does not include the actual underlying assets that are accessed electronically. So the underlying bank account that you access online, or the underlying 401k or brokerage account that you access online, those actual accounts are not considered digital assets, but the online account itself is. And also an employer's email system, because that is an area that's highly regulated, it is not considered a digital asset. So your family members will not be able to access your emails used through your employer's email system after you pass away. So it's very important to kind of keep your work email and your personal email separate to the extent you can. And also note that digital assets do not include items of intellectual property, and that includes things like copyrights, patents, and trademarks. Sometimes those are considered kind of techie types of things, so I just wanted to make clear that those items of intellectual property are separate from what we're talking about today. And if you have an estate that consists of any intellectual property, you'll want to consult with your estate planning attorney to determine how to plan for incapacity or death with respect to that property. So we get a lot of common questions regarding digital assets, and the main one is who's going to have authority to access or manage your digital assets after you die. So for example, a lot of people have Facebook accounts, so what's going to happen to your Facebook account after you pass away? What's going to happen to your iTunes music library when you pass away? How is a family member going to be able to manage your email account or pay your online bills? So there's a lot of us have large online presences, and this is just a small portion of what the questions might be, but it's something to get you all thinking. So there's a governing law that governs digital assets. There's something called the Revised Uniform Fiduciary Access to Digital Assets Act, which is quite a mouthful, and that establishes a scheme for designating who is entitled to access your digital assets after your death. Now that act, which I'll call the Revised Uniform Act, has been adopted in a majority of the states in the U.S., and California, unfortunately, well, fortunately, it has a very strong protection towards privacy of consumers. So in California, we adopted a very similar statute. It's known as the Fiduciary Access to Digital Assets Act, which I'll just refer to as the California law. And that act is a little less expansive than the Revised Uniform Act that's been adopted more widespreadly. So the Uniform Act that was adopted by most states extends to personal representatives, trustees, conservators, and guardians. Trustees, conservators, and guardians can act during a person's lifetime. A conservator and a guardian are usually appointed by the court, and a personal representative and trustees act after a person has passed away. So because of privacy concerns, the California law does not extend to conservators or guardians. So only trustees of trusts and personal representatives, like an executor who's appointed under a will or an administrator of an estate that doesn't have a will, are permitted to use the procedures outlined in the California law to gain access to a deceased user's digital assets. So in essence, the California law confirms the rights of fiduciaries to receive disclosure of digital assets held by a custodian after a user has passed away. However, at this time, as I had mentioned, the law does not grant fiduciaries the right to receive disclosure of digital assets if the user is still living, even if incapacitated. But the California law does confirm that as long as a fiduciary is acting within the scope of her fiduciary duties, she will be deemed to be an authorized user of the digital assets of the decedent. So if a fiduciary can access a deceased user's account or a digital asset that's not held by a custodian or subject to a separate terms of service agreement, and if that fiduciary has a password or can otherwise gain access to that asset, the California law allows that. And we understand that some of you who are listening today may not reside in California. The digital asset laws in other states, as I said, are generally more expansive than those in California, but please note that the legal aspects of this webinar address California law, but the practical considerations that you should all think about will apply equally to those of you who are in other states as well. So the California law, as well as the more widespread law in other states, establishes a hierarchy for how to appoint a designated recipient or a fiduciary for your digital assets. So the first in the hierarchy of 3, you can use an online tool to name a designated recipient or to otherwise express your wishes with respect to the account management after your death. So the online tool is very similar to a beneficiary designation that you might expect to see for life insurance or your retirement accounts. You can use the online tool to direct that a service provider disclose or not disclose your online content to a designated person after your death. You can use the online tool to direct the service provider to delete your account after your death rather than disclosing any portion of it to a designated recipient. So we have an example here of an online tool that Google uses. It's called the Google Inactive Account Manager. And Google allows you to make a plan for your account if you pass away or even if you're inactive for a certain period of time by some other reason. So you can pick the level of inactivity that needs to be had in order to have this go into effect. So it could be anything from, I think, 3 to 18 months of inactivity. You can select who to notify and what to share with that person once your account becomes inactive. And you can also decide whether to direct Google to delete your account after it becomes inactive. And here's an example of the online tool for Facebook, which allows you to name a legacy contact. And that legacy contact is a person that you choose to manage your account after you pass away. And please note that the legacy contact, it can pin posts, respond to friend requests, and update your profile photo, but the legacy contact will not be able to make posts on your behalf or see your lifetime messages. So a lot of times people are creating kind of memorial pages when someone passes away using that the legacy contact person to do so. Alternatively, if you don't want to have that kind of memorial Facebook page for yourself, you can choose to direct that your account be permanently deleted after you pass away. The second in the hierarchy is your estate planning documents. So if there's no online tool available, a person can designate a fiduciary in a will or a trust to grant the fiduciary access to the individual's digital assets. If there's a discrepancy between the person you appointed on using the online tool and a provision in your will or trust, the designated recipient that's named in the online tool will typically take precedence over a digital asset fiduciary that's named in your estate planning document. Third is if there's no online tool and the person did not give any instructions in their estate planning documents, then the terms of service that you usually don't read and just hit accept will govern. So those terms of service will usually have provisions as far as what will happen to the asset upon your death. There's a couple that are a little bit tricky. So Yahoo and Microsoft have terms of use that will automatically delete your account if you do not have any instructions in your estate planning documents. They don't offer an online tool. So it's very important to kind of keep track of what your digital assets are and know whether there's an online tool or not, and look at the terms of service to see if that's something you agree with. Because if you don't have an online tool and the terms of service direct that the account automatically be deleted and you don't put anything in your estate planning documents, then the access to those digital assets could be permanently lost.
Okay, so this is Laura now. Hopefully you've followed during your lifetime all of Megan's good advice about designating a fiduciary for your digital assets. And here's what your fiduciary would actually do when you pass away, or also some things to keep in mind if you are named as the fiduciary for someone else's digital assets. So on this slide you'll see there's some slight differences between the procedures that a personal representative would need to follow versus a trustee. And basically, trustee is someone named under a trust document. Personal representative is sort of catch-all term for an individual named either under a will or another written document. So in both cases, the fiduciary will need to submit a written request for disclosure. they'll need to submit a copy of the user's death certificate and then some sort of evidence of authority in their role as fiduciary. The custodian or the holder, so let's say Google or Yahoo, can come back and require some additional information. So you'll see that on the left side, they can require more information from the personal representative, including a court order, versus the trustee. So it's one thing to keep in mind if you're deciding between different estate planning documents to use to designate your digital fiduciary. In some ways, the trust is better. You also want to keep in mind that a fiduciary can request that the custodian delete the user's account by providing the custodian with all of this similar information. So this would be both for accessing digital assets, but also for deleting them. So this next slide shows the additional requirements if your fiduciary is trying to access the actual contents of electronic communications. Because the contents are highly regulated and are considered very private, there's a higher bar to gain access to the contents. So the fiduciary has to make an affirmative showing that the user who has passed away consented to this disclosure of the content. Versus for other digital assets, they really just need to show that neither the user nor a court prohibited the disclosure of the overall digital asset. So once you as the fiduciary have submitted all of this, what's the custodian actually going to do to comply? They have a 60-day period within receipt of all of the required information to actually comply with it. And then they can have 3 different options. So they can either grant full access to the fiduciary, they could grant partial access to allow the fiduciary just to perform necessary tasks in connection with the administration of the estate, or they might provide a full copy of any and all of the digital assets on a USB drive. If for some reason the custodian is being a pain and refusing to comply, then the fiduciary would need to go and seek a court order requiring compliance. So on a practical level, how can you make this easier for the fiduciary that you've named to actually figure out what your digital assets were? It might be advisable to keep an inventory of all of your online accounts, which I feel like I have a new one every day, and compile a list of all of your usernames and all of your passwords, plus the security questions that would help someone access those accounts. But you want to make sure that this is all stored very securely. So one way that people do this is through a password management system. There are quite a few companies out there. We've listed a couple here, LastPass and 1Password. Some of them may require a fee, but some are available at no cost. Another option is for you to create a password protected document on your computer. If you're going to do that, you might also print out a hard copy and keep it in a secure location, so like a safe deposit box or with your other estate planning documents. So the password management systems, like those mentioned on the slide, they encrypt your login information, like your username and your password, and store it on your computer. They make it a little easier so the person trying to access only needs one master username and password to access that stored data, and then you can easily retrieve and update login information as needed. So these systems allow you to grant access to another user in the event of your death. So we've also included one slide here in case any of you are far more advanced than we are and actually an owner of cryptocurrencies, or if you're thinking about it. So we're referring to things like Bitcoin, although there are quite a few more out there. So Bitcoin is an encrypted virtual currency and more popular these days. if you are an owner of Bitcoin, you have a private key, or also essentially a password that allows you to have secure access to anything stored in your digital wallet. So how are you going to actually pass that along to your loved ones when you die? The owner of Bitcoin would have to be very careful in leaving that private key to their loved ones. Otherwise, essentially, the Bitcoin is inaccessible and the value is lost. So this is a little different from other digital assets. You have to be even more careful. Just leaving the general instructions in your estate planning documents, unfortunately, wouldn't get you there. Alternatively, you can use a third-party vault for your private key if you do have any cryptocurrencies in your estate. So now that we've given you an awful lot of information on digital assets in general, what should you actually turn around and do after this presentation is over? So I would start thinking about whether you want to give access to your digital assets to someone. And if that's the case, would you want them to additionally be able to access the contents of your electronic communications? Because you can carve out that they cannot access the content or not. Of course, you should always talk to an estate planning attorney. And when you next speak with an estate planning attorney, ask them, are the digital assets covered if you have existing estate planning documents? You know, if you do have a trust, were your digital assets properly transferred to the trust or not? Do your estate planning documents appoint a specific digital asset fiduciary? So sometimes we see clients name a trustee who's going to address the rest of their assets, so things like real estate and investments and their cash accounts, but maybe they have a different individual who they would want to be in charge of the digital assets, in which case you can name this separate person in your existing estate planning documents. You should also periodically review the selections you've made using an online tool. So for your inactive account manager, if you have a Gmail account, they actually kindly send you a reminder every once in a while saying, here's who you've named. Make sure that that still is consistent with your wishes. Take the time to take the inventory of your online accounts and safely compile all of that login information that we talked about a few slides ago. Store that in a secure place. And then you visit each of your online accounts like Facebook, like Google, and use the online tools that are available. That's sort of an easy starting point if putting a full estate plan in place feels a little overwhelming. That's something that you can go and do today. Name that digital asset fiduciary for any of those accounts and make the other decisions that would govern that account after your death. So hopefully we've left you a little bit of time for questions, if anyone has any.
Wow, I've got a lot of questions myself. Oh my gosh,
Okay.
That was amazing, you know, because it's something that people don't really think about, but it's so important. It's a big part of our life. So
Yeah.
I would say, so one of my questions, and please use the chat box to drop in your questions, and we will make sure that we have some time that we can answer it. And also, by the way, because these are recorded, everyone will get a replay link, so you'll be able to, you know, take copious notes and be able to institute and implement some of these ideas that they're sharing with us. So the question I have for you then, maybe you can share a story about what happens if somebody doesn't appoint. Have you experienced some situations where someone's online social media life just kind of got torn apart? Or, I mean, what are some crazy stories that you can share with us?
I don't know about if it's crazy, but one that I've unfortunately seen personally in the last year a few times is people our age passing away who have Facebook accounts passing away unexpectedly. And, you know, especially younger people, as well as many of our older clients, they just don't want to think about their estate planning. They feel it's too morbid. So for these younger individuals who've passed away, they especially have not put any estate plan in place, and they also haven't taken the time to even use the free online tools that are available. So you see family members who are left behind then struggling to sort of guess at what the passwords would have been to take down a Facebook page, especially if you know, and having to contact Facebook sort of randomly and through whatever publicly available information is there to stop, you know, maybe other people posting things that they wouldn't want on the page.
Sure, sure.
Yeah.
And the password manager recommendation, I think, is really, really critical. I have had some clients where the spouse was ill. They didn't pass away, but they were ill, and were in the hospital. And the remaining spouse, in this case, it was the husband. The wife was in, you know, and hospitalized, and it's usually the case. Women tend to be, you know, the budget, the cash flow. We handle the checks and check writing, but he did not have access to any of the online accounts, and they didn't really have a checkbook. So they were paying everything online. So the mortgage, the utility bills, everything got swiped. And it took a while because she was in the hospital for some time for them to kind of get stuff straightened out so he could pay those bills. But he actually physically had to go to the bank. and get you know, get checks made and send it out to the respective companies. So that password manager recommendation, I think, is tremendous. And for anybody that's on this phone, or on this call rather, as it was noted by them, these password managers are fairly inexpensive, but they can save your life. Even if, like me, your memory might kind of go sideways there, and you're like, what is the password for this site? So I use a password manager. But being able to give someone access to that would really be a tremendous assistance and help, you know, if you're incapacitated or if you do pass away. So,
yeah, and those password managers have online tools themselves typically where you can name a person to get access to your password management system if something were to happen. So, so if you do open up a password management account, then look for that in the advanced settings so that way a loved one can get access to your passwords to the extent you pass away.
All right. Extremely. This was amazing. Thank you both so much for your content, and I know it was a short period of time and you covered some very heavy-duty, in-depth, intense areas here, so hopefully we will, you'll be able to access some of our community and vice versa. So everyone, their contact information here is, you can see, phone number and email. And just as this particular presentation was amazing, they did a great job at the FPA LA chapter meeting as well. So with that said, I want to thank everyone for your time. We'll send out the replay links today. And thanks, everyone. Have a great weekend. And we look forward to having you on our call next month.
Great. Thank you.
Thank you.
Thank you. Take care.